everybody, welcome. It is 11:30. This is a presentation that myself, Eric Tonsel, and Teddy Holtz are going to be giving to you today. It is Tweet Others as You Would Like to Be Tweeted. We're going to be talking about social media with respect to property owners associations. And so we're going to be going through the do's and don'ts and issues involving social media and going to go over some statistics and all kinds of good stuff. So before we get started, the information presented today is based on the laws that exist today, August the 10th, 2021. It's for educational purposes and does not constitute legal advice. If you need legal advice relating to any of the topics that we discussed, please consult your attorney. So on to the next slide, please, Lindsay. Before I forget, we did receive some pre-submitted questions with respect to today's webinar, and so we'll be addressing those questions at the end of the presentation. Also, if you do have any questions during the presentation, feel free to type them in the Q&A, right, Kyle? I believe that's correct. The Q&A section, not the chat, the Q&A, and we'll also get to those as time permits at the end of the presentation. So without any further ado, historically, the attitude or mentality toward social media with regard to community associations has been kind of negative, to be honest with you. It's the perception has been that it's not ideal for community associations because there's potential for giving owners a platform to attack board members, to attack their neighbors, post images and photos and stuff that may not be very flattering towards other people in the community. And so those are a couple of the issues. Also, there's a perception that it may create more problems than it solves, and it may increase potential for liability. For example, if a board member or a representative of the association were to post something that could be construed as being defamatory against an owner, then that might subject the association to potential liability for a defamation claim. And so those are some of the issues and concerns that relate to social media. And then also the free speech concern. First Amendment is a real thing. And so owners have the ability to put, so long as it's not defamatory, of course, they can put whatever they want for the most part on a social media platform. And so, and there's really no way to regulate that. So that, again, opens up the association to just negative comments, criticisms, and that kind of thing. So historically, that's kind of been the mentality, just stay away from social media. Next slide, please, Lindsay. But, social media, as you'll know, is basically here to stay. I'm going to go through some statistics here in just a little bit to give you guys an idea of what those numbers look like. But, because social media is here, because it is so widely used by many people, this presentation is going to talk to you about strategies as far as implementation of a social media platform for your association, kind of the do's and don'ts. Or did your screen just go black? Anyway, we're back. Sorry, my screen just blanked out on me for a second. So we're going to talk about implementation of a social media policy for your association, and we're going to also talk about unofficial pages that are started by not people who are not on the board or not affiliated with the association, just owners within the community, and how to address and deal with some of those issues that arise from those unofficial pages. Next slide. So let's talk about the stats. First, let's talk about email. So email, as you can see, a gajillion emails are sent every day, every second, 90 trillion each year. And 90% of those are junk, obviously. But so that's email. There's still, don't get me wrong, there's still a lot of emails being shot back and forth. But next slide, please. It's the demographics that we need to look at it with respect to emails. Many of us are very comfortable with emails, obviously, but email use has dropped 59% for 12 to 17-year-olds. And why is that? Well, because they're on the Instagrams, they're on the Facebooks, they're on the Twitters, they're on the Twitches, they're on the whatever platforms are out there that I'm too old to know even exist. They're all out there. And so email use has dropped 8% overall. 18 to 54-year-olds are using email less, while 55 and above are using email more. But the point being is that the demo, especially 55 and under, is trending more towards social media, like your Facebooks or your next doors, that kind of a thing. Next slide, please. So Facebook still skews young, but the 45 to 54-year-old bracket has seen a 45% growth since 2012. And so there's a huge push towards the use of social media in the last 9 to 10 years. And the crowd is getting older. It's not just the 12 to 17-year-olds anymore. It's, heck, my mother is on Facebook and she's in her 70s. Oh wait, I mean, she's in her 40s. I shouldn't say that. She'll get mad at me. So the point being is there's, these social media platforms are not just relegated towards the younger, millennials. Everybody's using them at this point, and it's the fastest growing segment of social media users is it's just getting up there. So we need to address it. Again, the point being is we can't, you can't argue the fact that social media is here to stay, at least for the relative future, and we need to be able to use it to our advantage and kind of move away from the mentality from the good old days where we said don't do it, bad idea. Next slide, please. So as far as Facebook and Twitter, more stats: 1/6 of the population uses Facebook or Twitter. There's over 250 million active users of Facebook on mobile devices. 155 million tweets are sent every day, and there's all kinds of versions of Facebook. And I know that a lot of associations actually use Facebook Facebook Live to stream their meetings. That was a question that was submitted prior to the presentation. I'll address that at the end of the meeting. But the point being is Facebook and Twitter and all these things, they are used and they're used often. And so we need to be able to deal with it. And we're going to talk about that in just a little bit. Next slide, please. So if you want to utilize social media, and when I say you, I'm referring to the boards that are listening to this webinar, need to come up with a plan. How are we going to do this? What are we going to do? What's going to be the purpose? That kind of thing. So we got to establish what is going to be the purpose of the use of this social media. One is to, send out information to the community, keep the community informed of what the association is doing. Also, not only that, but in the event of national or a natural disaster, assuming you still have power, of course, it's a very good tool to send communications to the members of the association as to what's going on and provide helpful and useful advice. As far as, like, for example, the freeze we had in February, I know majority of us didn't have power for extended periods of time, but when you did get power back in those rolling blackouts or brownouts, you would hop on your phone or your computer and be able to get some valuable information as to what was going on. So that's a very important thing. Another step is receiving information. It'll gives the owners an avenue to communicate with the association and provide, hopefully helpful, suggestions, comments, concerns, whatever the case may be. So it opens up that dialogue by and between the board, the management for the association, and the owners. It also fosters communication, as I just said, between, with members, between members, and that kind of thing. And so we need to limit the content to the purpose. And what I mean by that is we strongly recommend that if you do have a social media platform, that you adopt a social media policy. I'm going to go into the specifics of that in just a second. But the policy is important because it does allow the association to regulate the content and the information that is shared and uploaded onto the social media platform. And the social media policy could be anything. It doesn't just have to be a Facebook page. It could be the association's official website. It could, or something that you have control of. For example, Nextdoor, you really don't have control of for the most. I mean, you can assign admins for Nextdoor, but I would suggest, something that you have, much more control over, like a Facebook page or your own association website, something along those lines. Next slide, please, Lindsay. So what is in a social media policy? Well, first, it includes the terms of use. You identify the purpose of the policy in the terms, and identify the purpose of the social media platform in the terms. For example, you could have community-related posts regarding lost pets, classifieds, social activities, advertisements for, hey, we're going to have an ice cream social in the park this Saturday, whatever, and that kind of thing. Nothing obscene or unlawful. It will prohibit anything that's obscene or unlawful from being posted onto a social media platform. There's be a prohibition against harassment or threatening comments. You refrain from posting copyrighted material or images. No advertising or junk messaging. Now, the advertising, it's subject to within reason. Again, that kind of goes back to like the classifieds. There may be kind of a fine line there that you will make a delineation in your policy as to what is or is not acceptable to be posted on a social media platform. And then no personal information about your neighbors, no gripes, no images. If your neighbor has a deed restriction violation, you can't go and take a picture of your neighbor's violation and post it on the social media. That's not what we're here to do. Next page. Next slide, please. Thank you. The policy, as we draft it, allows the association or the admin to excuse me, delete content without notice to the person who posted the information on the social media platform. Also, it allows the association, if there's repetitive violations of the policy or just a really egregious violation of the policy, you can actually allows you to terminate the user's rights to access and post and participate on the social media platform. And the important thing to consider here is who is going to be the administrator. You could either have a board member, you could have a committee member, you could have your association's manager. Now, keep in mind, if you use your manager, there may be a cost incurred for having them be the admin for your social media. Again, there's no right or wrong answer here as far as who's going to be an administrator, but what you do want to keep in mind is that you want to have somebody that is vigilant, that is, actually monitoring the social media platform. You don't want to have an absentee father, running the show, because there may be all kinds of nastiness being put on that social media and nobody's minding the store. And so you could end up getting into some hot water there. So again, make sure whoever it is somebody that is dependable and reliable enough that they're going to check on it and make sure that, everybody is playing nice and playing by the rules. So again, these are our recommendations for if you do decide to adopt to have social media. A policy it's pretty much a no-brainer. I'll just be honest with you. You want to have that ability to regulate the content that's placed on the social media. You don't want to have, because if you don't have a policy and you just have a social media platform, and then somebody posts something and you strike it and cut it down without any kind of notice or anything, the owner or whoever posted may have an argument that you're violating their First Amendment free speech rights. And so that's why this policy is important. The social media policy can be adopted unilaterally by the board. It does not have to be a vote of the owners of the association in order to adopt a social media policy. It is a dedicatory instrument, so it will have to be adopted at an open board meeting for which proper notice is given to the owners. And once it's been voted on and adopted by the board of directors or trustees, whatever the case may be, you execute it, you sign it, and then you have it recorded in the real property records of the county where your subdivision is located. And once that's been done, then it is enforceable at that time. So that's a little, social media policy 101. If you have any further questions about it, feel free to put them in the Q&A. And now I'm going to kick it over to my colleague, Teddy, and he's going to talk to you about some other important things to consider most specifically unofficial pages, but he's going to be talking about some other things as well. So Teddy, please feel free to go ahead.
Thank you, Mr. Tonsel. Good afternoon, everyone. I'm Teddy Holtz. I'm an associate with RMWBH. So switching gears a bit to unofficial pages here. Our firm has seen a lot of this sort of stuff over the years, and I kind of want to run through some of the more common things that we see. So, maybe a disgruntled owner or someone who is adverse to the board in some regard will, of course, maybe get in their mind to have a vendetta of some degree and act on that. Of course, they take, as so often happens nowadays, to the internet to do so. So when they create an unofficial page, they may do something like try to lodge an assertion of criminal history of the board member, of one or more board members. They may do things like post a mugshot on an unofficial page of the board member, put their criminal conviction, the actual judgment order of the court to show what the conviction was. They may also just blast the association's budget and other sensitive documentation of the association on a page, when in fact those documents are really only available to the membership of the association itself and not to the general public. And they're doing so to kind of invoke what Section 209-00591 of the Property Code provides, which is board members, if they are presented with proof, written proof or documentation of a criminal history, namely a felony or crime of moral turpitude within the past 20 years, then a board member is disqualified at that time. And of course, I can discuss really quickly what a crime of moral turpitude is. So if it's not going to be a felony, your most often one is theft, a theft conviction, which is a misdemeanor in a lot of regards. Or they will just willy-nilly create a false criminal history without any sort of proof or whiff of proof at all. So none of that's good. And, of course, it's something that needs to be tamped down as much as possible. Next slide, please. Also, we see defamation a lot of times. So a written statement will be libel, but a verbal spoken statement is slander. I'll kind of give a quick example. If I were to say right now, for illustrative purposes, that Eric Tonsel is a convicted thief. Well, I'll say this, if he actually is a convicted thief, then I'm in the clear on a defamation suit because truth is a defense. However, he is a fine, upstanding man. He has never been convicted of theft. So I would be in trouble should Eric bring a defamation action against me. But what I just did was spoken. I didn't write it. It's not written down. But if I wrote that on a social media page, then that's considered libel instead of slander. So it's defined as the invasion of a person's interest in his or her reputation or good name. It is very important to note that the association does not have a claim or cause of action. And why is that in that regard? Because that claim only belongs to the individual director who is being slandered. So if that is to occur and that director of the board goes to their legal counsel to ask what they should do, it's not the sort of thing that the association can refer over to its general liability and D&O carrier for a claim on its insurance. Instead, that individual holds its own cause of action as opposed to the board as a whole having cause of action. So in that sense, the individual must retain their own legal counsel and pursue their claim totally individually and separate and apart from the board or the association's resources. So with regard to unofficial pages, what can or should an association do? More to give a very general answer to that question, it is always better for the association to take the higher road, as it were, to not get in the weeds, get on that unofficial page and create a lot of chatter, responses back and forth, as we so often see in the comments section of any website nowadays. It's a cesspool, y'all. We all know it is. So the best thing to do instead is to have an indirect response, whether that be through a bulletin, newsletter, e-blast. However, it should not be lodged on the site with the original content. So if it's a Facebook post, if it's a Nextdoor post that is rabble-rousing, the board does not, it's recommended that the board not post there or give a direct response to that. Hey, free thinking, it still exists these days. What a concept. So please instruct your membership to investigate and verify their information before posting. That's more of just a common sense sort of thing. We all want to get down to the bottom of things, but if we're just lodging wild accusations left and right, that doesn't really get us anywhere. So really the membership should be told to, look into this themselves to some degree. And I mean, of course, you're giving the board's position, the board's point of view on something, but so long as it's measured and not a very passionate response is probably the best approach here. And that will get you, some better results going that route. Posts or comments regarding the character or reputation of individuals may trigger litigation or liability. And that's very true. So in the sort of sense where an individual board member responds on unofficial webpage, that can get the association into some hot water, because the membership could take that individual post and think it's coming from the board itself, and the association is giving that statement. But when in reality, it is just an individual's point of view, one of many board members. So that's something like that could get the association into some trouble going that route. And these unofficial pages obviously are not productive for the community. The association, to the best of its ability, should obviously redirect the membership to the actual official communications and official social media pages of the association to receive the best information on these topics. So for an unofficial page, you're more likely to experience, the most likely experience may not involve defamation. It may be other things such as calling into question an action or statement of a manager, management company, or the board itself. Of course, that gets that can obviously stir the pot and get the membership riled up very quickly. They could question spending or decision-making, and they obviously are a drain on resources, because the association has to, they don't have to, but of course the association may want to respond, may want to address it in a meeting. And obviously it's just wasted time, resources, energy to have to do something like that, when really the association just wants to carry on with its business and not get down the weeds on these sorts of accusations that are lodged. And of course, it fosters doubt throughout the community. So again, these unofficial pages are really just that. They act to distract the membership and steer them toward the originator's line of thinking, as opposed to what the association is trying to do with its official communications. So what can the board do with these sorts of unofficial pages? Well, of course, first and foremost, a polite request to the user to remove the page. You could see results, but probably not. So then you have to turn up the heat just a little bit and decide what else to do after that. Reminding the membership of the official sources of communication. I of course mentioned this earlier. It's a very important concept to get them back with the official procedural, what was the word I'm looking for? Procedural, the best course of action for the association, just getting them toward the official lines of communication, the official procedures and holding meetings, that sort of thing is the best course of action. So inviting folks to attend a meeting, demonstrate that transparency with regard to the issue at play, and of course, recognizing new members in meetings. So if these members want anything or request documentation, certainly they're free to do so under the open records policy and in those statutes. And as well, of course, we all see the problem owners in our communities and what they have to say at these meetings, but there is, of course, a lot of credence to be given to the sort of logic that giving these people their platform, their time to be heard, is going to really benefit the association down the line. So of course, give them their chance to be heard and speak their piece, and then you can move on from there. So if your association is saying, we just don't like what they're saying about us, well, as I said, if the association gets down in the weeds with these folks who are on the unofficial pages, and individual board members are in the comments section, really giving their own responses, then of course you're going down the rabbit hole doing that. So attempts to silence folks may backfire. And you can really trust your members to verify their information before they form an opinion. So you may have the sort of situation where the unofficial page is really fooling a lot of the membership into thinking that it may be an official page for the association. Well, then in that sort of case, you really want to make that concerted effort to redirect the membership and let them know this page is not official. Your only official communication from the board is coming from your e-blast, newsletters, bulletin, association designated webpage, and go from there. And of course, emotionally charged, as I said, that's what they're intending to be. But the best thing to do is stay in the course. Time is your friend, of course it is, because like any sort of thing, hot button issue, hot button, whatever's going to be in the media, as we've seen time and time again, time really does heal that sort of stuff. And, before you know it, you're on to the next hot button thing. And so something can get, kind of lost from there. And that will really be to the association's benefit with regard to, that one rabble rouser who has their pet issue and just won't, be silent about it. Then, you just wait for the next thing. And most often you'll be okay doing that. What if you really don't like what they're saying about you? Well, and the board is saying, well, we have to do something. Well, in these sorts of situations, it just does not behoove the board to, again, put all these resources and drain resources in doing so, because, again, it could take a years long tit for tats. There are just a waste of time at the meetings and in their personal time, just respond on social media. If you wanted to, you could obviously get with your attorney and see if they recommend filing a lawsuit or defending a lawsuit. But, again, wasted resources and just going down that rabbit hole even further and maybe making things worse. If the membership then, or the rabble rouser then gets the membership to meet that quota for a special meeting to be called, of course, that is, again, its own drain on resources and time, because you do have to call that meeting and make sure it's conducted with officiality and following, the lines of the law there. Again, multiple community meetings where this is discussed, just waste of time. The media could get involved. Negative public perception outside the community. So I'll just kind of skip to that point, because it's a no-win proposition here with regard to social media. I mean, if I call Eric a thief, he says, no, I'm not. Then I say, well, I think, I have all this proof, ABC pieces of exhibit. He says, no, you're full of it. Then, I mean, how much time did I just waste just then? I mean, it's just, it's silly just going through that back and forth. So it exhausts people, and it could even lower the property values. I know I've heard of incidents where realtors will actually go on the official Facebook pages or even conduct a Google search and see the unofficial page and be like, this is just a toxic community with toxic people in it, because they just can't get it together for some reason. Well, then that could actually lead to lower property values in doing so. So again, it's maintaining those official lines of communication and doing what you can to redirect the membership from the shiny object that is the unofficial page. So to conclude, as we discussed, I don't think we're telling you anything about social media in general that you don't already know. It certainly has been a cause for good in bringing, our world much closer together. But at the same time, it has divided us in a lot of ways, just with misinformation and distractions. So for your own community, it may not be a good fit, but that, for now, that could be the case. But in the future, as we see people really moving towards social media and making it more of an established line of communication, it's obviously a social media policy is a good idea to respond to that. So, and of course, that's good planning. And you really should adopt that social media policy to obviously dictate the terms yourself and make sure that the membership knows what they can and cannot do on the official association Facebook page or website. And again, as to unofficial sites or pages, complete control is not the goal. Really, it is best if the association just redirects toward its official line of communication and does not give those direct responses to the unofficial pages. And informing the membership, always a good idea. So keep those bulletins, e-blasts, email correspondence going, so that they are not, totally distracted by the unofficial pages that they can go to. Okay, and so at this time, we'll start going through the pre-submitted questions. I know we've had some Q&As asked during the presentation, but let's go ahead and get to those.
Yeah, let's start with the Q&A first, Teddy. And also,
Okay.
want to make a point of clarification. The social media policies don't apply to the unofficial pages. The social media policies apply to the official association social media platform. So your website, if you have a official Facebook page, that's what the social media policy applies to. If an owner creates their own unofficial page, the social media policy does not apply to an unofficial page. So I just want to make that distinction. Nobody asked that question, but I just want to make that clear to everybody.
Mm-hmm.
All right. So the first question, we have an official Facebook group moderated by the community manager under the association's social media policy. Some members post clean jokes that other members like. It's not specific to the community, but it fosters a positive environment, and I don't delete them. Should I? Not necessarily. Again, there's no reason to. Again, if what was being posted was in violation of the terms and conditions of the social media policy, then yes, then at that point, that's what needs to be deleted. But just clean jokes, there's no need. I wouldn't worry about that.
Yeah, it's pretty harmless.
Right,
so the next question is, we approve all our items on Facebook. Oh, no, I'm sorry, I skipped ahead. Is an HOA a governmental entity for First Amendment purposes? The answer is no. Our associations are nonprofit corporations. They are not governmental entities. So of course, as I have seen time and time again, when I see people crying First Amendment free speech violations, so often, it's not a governmental clampdown on their speech. So you of course see this on Facebook, Twitter. Those are, the carriers of this content. But they can, delete me for saying happy birthday to someone, and I really don't have much recourse because they are not a governmental entity. So of course your association, so long as it's sticking to the policy and maintaining its governance there, you're going to be okay with regard to clamping down those sorts of statements that you see on the official page.
And excuse me, the other thing to point out, Teddy, is that when you're monitoring and your admin is monitoring your social media, you have to be fair and consistent across the board. You have to treat everybody the same. You can't be arbitrary and capricious. So you can't, if somebody keeps posting something, you keep deleting them, or somebody posts something similar and you leave it. Well, now you have accusations of discrimination for not treating everybody the same. So keep that in mind. You have to be uniform in your enforcement and your monitoring of your policy. All right, next question. We approve all our items on Facebook except when we have meetings. With this policy, can we remove the bad comments at least the next day? Well, the answer is it depends. And what it depends upon is whether or not the bad comment is somehow in violation of the terms and conditions of the social media policy. If it's just a negative comment towards the board that doesn't necessarily violate any of the terms and conditions, then no, you cannot. Well, you could, but you may be subject to challenged by the owner and saying, hey, why did you delete that? I was in violation of the terms and conditions. Now, if it's something that's clearly in violation of the terms and conditions, then yes, you can. So this isn't necessarily a way to censor anything that's said by an owner against the association. You're going to have this platform. You're going to have your rules. So long as people follow the rules, they do it because not everybody's going to have this a positive opinion about everything. Let's be real. However, if somebody does it professionally and they have a counterpoint or counter opinion about something, and they present it in a respectful and professional way, there's no need to remove that. That will comply with the policy. So keep that in mind when you're when you're looking to potentially remove quote unquote bad comments from social media. Mm-hmm. You want to take the next one, Teddy?
Yes. What if a homeowner has created a Facebook page for a community that's
sorry.
That one got deleted. Let's see. You see where that went, Eric?
I do not.
Yeah. Okay. Well, sorry about that. I will go on to the next. What is the HOA's liability responsibility if an HOA board member is running an unofficial page with the name of the HOA in it? So as far as liability and responsibility goes, the association could do that. I guess it's doing its due diligence to send a written request to the moderator, the operator of that unofficial page to take it down. But past that, the association won't be all that liable to me, because you will have that written proof that the association tried to do something that you can, of course, show in court later that the association took that action. But past that, there's really not a whole lot of liability or responsibility, so long as the association has sent that written demand, as well as informed its membership to also go back to the official lines of communication.
On top of that, Teddy, it's never a good idea for a board member to have their own social media platform for the association that's independent and distinct from the association's official social media platform. It's just not a good look. We want to have a unified front. When a board makes communication to its owners and members, you want to have a majority of the board agree on what's going to be distributed and said to those owners, because you may have varying opinions on the board as it relates to any topic. But again, you have to have a unified front. You can't have one board saying something that's contrary to what a majority of the board is, their opinion of the matter. So just having a board member having their own, again, I'm not saying they can't have a private Facebook page or their own personal Facebook page. That's fine. What I'm saying is having a board member create an unofficial, Facebook page for ABC Association Inc. And that's where you're going to run into some issues. So I would advise against doing that. That's never a good idea. And so on to the next, I think the next question kind of ties into that. Can the HOA be held accountable for what a board member says in their unofficial social media site about the HOA and its business? The answer is potentially yes. It depends on what is said, because that board member is a representative of the association with apparent authority to act on behalf of the association. And so if a board member makes a statement as if it were fact on an unofficial page, and people rely on that fact to their detriment, and it turns out not to be true, the rest of the board is going to say, well, no, we didn't agree with that. We didn't talk about that. Well, that particular board member has that apparent authority to act on behalf of the association. So the answer is it depends. It depends on what the communication is. But is there potential liability? Yes. Can this association be held accountable? Yeah, possibly. Again, it all depends on what is being said and what we're talking about here. But the answer is yes, there is a possibility for it. And the last one, you take the last one, Teddy?
Yes. Can an HOA social media policy state that board members or committee members cannot talk about HOA business on unofficial sites? I want to stress that the social media policy is really more directed at the members and what the members can and cannot do on the official association page. So as Eric explained earlier, it really does not deal in any way with the unofficial pages. And I think you'd be getting just a tad bit in the weeds with regard to liability if you were to include that into the association social media policy, because it's just, and again, I also foresee some problems with regulation about that, and what the association would really do if a board member was found posting on an unofficial page. So probably best to leave that out. But Eric, do you concur with that?
I do.
Mm-hmm.
Do you want to take this last one? I'm looking at something else real quick.
Yeah, of course. You mentioned the First Amendment rights to free speech, but can the HOA restrict some of those rights under the auspices of having a signed contract, the restrictions, which allows them to do so? So, I mean, you're exactly, I think the spirit of this question, I definitely concur. You can, restrict people's rights to a degree. And again, the First Amendment is inapplicable to the association's social media policy and how it conducts its official website. Of course, we get into the realm of defamation to some degree, and that is covered. But with regard to the association doing anything to, delete comments or delete a person off of their website, making that call will not invoke the First Amendment. So I think I answered that question.
All right, now I think we're done on the Q&A. We have a couple of questions that were submitted beforehand. We'll go through those very quickly. A lot of them we answered during the presentation, so I'm not going to revisit those. Let me pull it up here. 1 second. Excuse me. So the first one is how to control membership and access in social media such as Facebook. We talked about that. How to handle Facebook pages using different names containing the subdivision name. Are there any rules governing this? Example, Sunshine Community Residence, Sunshine Community Official, Sunshine Community Private. The answer here, it depends on how close the name is to the association's actual name. If a reasonable, ordinary, prudent person wouldn't be able to tell the difference, if they looked at it and thought that was the official page, then my recommendation would be to contact the individual who has started that page and say, hey, look, your name is, the name of your page is way too close to the actual name. Please change it, or at the very least, add a disclaimer onto the homepage of the social media saying, clearly delineating that this is not an official social media platform that for ABC Association Inc. At least you have that out there so that it puts people on notice that that is not the official communication or official platform of the association. So who can post on the official Facebook page? Is this the board or management? Well, it depends on what the board wants to do on that. If you want to have management be able to have access, then you can do it. If the board only wants to have board members, they can do it. But again, as we said, we're using in this case, the Facebook page, we're using it to foster communication to and from the residents. So you want to be able to have, everybody be able to have access to be able to post. Again, that's where the social media policy comes into play, and it's so important because you have the ability to regulate comments or things that are put on the page that shouldn't be there. So that, again, that's the reason why the social media policy is so important. All right, Teddy, I'm going to read this next one. I'm going to have you answer it.
Yes, sir.
How can the resident portal be useful when residents seem to prefer to get event news from Facebook? Can both be updated simultaneously? How does a board manage this?
I believe, and Eric, what do you think about this? I mean, I think the question is getting at both an official page that the association has versus their official Facebook page as well. So maybe two official lines of communication.
Yeah, there's many management companies in particular that have these resident portals where you actually have login credentials, and that gives you access to everything. So it's not open to the world as maybe just a website might be. Yeah. And so can both be updated simultaneously? Answer is it depends on who's running your website, your social media. That'd be a question for them. I mean, can you do it? Yeah, sure you can, as long as you have somebody that's ready, willing, and able to do that for you guys. So it depends on your management company, or if you're self-managed, whoever's handling your portal and your Facebook page in this case. But yeah, certainly you can do that, but it's just, it's a matter of having the right, the personnel available to do that. Why does management charge for mass emails? This seems to be the best way to let residents know things, especially in smaller subdivisions. Is there a way to reduce this charge? Well, that is not really a question for us. That is a question for your management company to talk to them about, what they are or aren't willing to do with regard to charging you guys for emails. If a private group of residents establishes a social media platform, example, Facebook, should the board take on the responsibility of monitoring it? If the board does not want that responsibility, can the board require that the private group post a disclaimer saying the webpage is not sanctioned or monitored by the board, and that official messages from the board or management company come through a portal maintained by the management company? Any other advice about how the board should interact with the social media platform that it does not sanction or control? We answer the lion's share of this in the presentation. Teddy, do you have anything to add to that?
No, and I mean, again, with unofficial pages, by themselves, I think a lot of times they are problematic, or they can be problematic really quickly because they're created more or less for that purpose. But one that just is somewhat idle and not out of control yet, I don't think the association has to necessarily, send that written demand and say, take this down immediately. But if it is causing a disturbance and really deflecting, the membership away from the official lines of communication, I think that written demand should be sent to the moderator, the originator of that content, to take it down, because it is causing problems and it is not the official communication.
Right.
So from there, unless it becomes a major problem, I kind of would advise that written demand be done, and then just reassess after that.
All right, one more for you, Teddy.
Mhm.
When children are caught on camera breaking community rules, pools in this case, and the board wants to identify this child, is there any appropriate way to post this on Facebook for identification?
Yeah, this is a touchy one, isn't it?
It is.
So where I come down on this is, I think any sort of information, surveillance, that sort of content can be posted, certainly if you're trying to assist law enforcement in in a criminal investigation context. I think if it's the sort of thing where, breaking community rules, and this seems a little generic to me, just it says pools, so I don't know if it's the sort of thing where they're, just roughhousing around the pool, or is it a criminal trespass at the pool? That would be two very separate things. I would say in the context of, trying to enforce the restrictions or doing something like that, maybe dissemination on a Facebook page is probably going to open a can of worms more than it's going to assist with anything. That's kind of where I'm coming down on it. I think so. So again, I think criminal investigation, yes, you can blast it, and I think you're perfectly within your rights to do so. But if it's really just to, clamp down on some roughhousing, I just don't. I would advise against it. But what do you think, Eric?
Yeah, I agree with what you said, Teddy. And you also got to be careful when you start posting pictures of minors on public platforms like this, privacy concerns and that kind of thing. So,
Yes.
if it's really case by case basis. This is something where, this isn't a one size fits all answer, although you did a good job, Teddy, of putting it in a one size fits all scenario. But if you do have an issue like this is definitely something that you should contact your legal counsel to discuss. What are we, are we subjecting ourselves to something, some kind of liability here if we proceed down this route? And the last question that was submitted: does a community have to have social media when it could be turned into a negative by residents? Answer is no. You don't have to have social media if you don't want it. I do think, well, you do have to have a website now.
Yes.
Per the new laws for 209 associations. Let me be clear, not for condos.
Of 60 or more lots, or those that contract with the management company.
That's correct. That is
Yes.
correct. So, if you don't have an a website, if you have 60 or more lots, or you have contract with a management company, you now have to have, well, effective September 1st, you have to have a website for the association. So I guess the answer to your question is it depends. But, again, a website is different than like a social, like a Facebook page, for example, where there's back and forth. The website doesn't have to have comment section. It could just be something you post, dedicatory instruments and notices about, information about the community. So there's a little bit of a distinction there. So we have 3 more questions on the Q&A, and then we'll shut it down after that. We maintain an official Facebook page, not a group. Having a page means that it is locked down and homeowner commentary is not allowed. But what sort of policy do we need to keep board members from engaging, arguing with owners on other social media sites? Well, there's not really a way to, you could have a code of conduct policy drafted, which that could be used to, rein in board members that want to go out and joust on like Nextdoor or something along those lines. But to be clear, there's no requirement that a board member has to sign that document. So if you prepare a code of conduct, again, the property code states, and again, in the 209 context, as to your right to run to be on the board, and it doesn't say anything about, well, you have to agree to sign a code of conduct in order to be on the board. So there's that issue. But I would think a better thing to go about, a better method to address that would be at a board meeting, an executive session, to have a discussion with that board member about, hey, look, you can't be doing this. Here's all the negative consequences. You're just creating more, you're causing more harm than good by trying to, duke it out on these other social media platforms. So maybe just a little come to Jesus talk with a board member as far as the negative ramifications that are a result of their actions might be enough to rein them in and not have to deal with that.
Mhm. I'll take, the president is the admin for a Facebook page, but the HOA does not have a social media policy. So is this still an authorized Facebook page? Of course, I don't know, all the details of that specific situation, but to me, it sounds like this is something that maybe just the one board member is running. And that's why I think it is important, again, to have that social media policy in place so that you can obviously, decide what's official versus unofficial, because here that does create a gray area to some degree. I think in this context, it's something that the board should get together and discuss to determine if that is going to be the official association Facebook page, and then create the policy so that that is made clear.
Yeah. The existence of a policy does not in and of itself make something authorized or unauthorized.
Correct. Mhm.
So be clear on that. Here's a criminal trespass question, Teddy. I'll let you take that, given your history.
Yep. Thank you. History being a former prosecutor, not a criminal trespasser. Let me clarify that. So does criminal trespass constitute the pool is closed or out of open hours? So a criminal trespass is really a trespass onto private property where the owner of the property has asked you to leave and you do not. A lot of times that I could get into the criminal trespass affidavits that the private property owner can have. That's a whole other presentation, really, on the how that would play out. But that is really how that plays out. Is a person, kids may want to get in the pool after hours and jump the fence. That's a criminal trespass because they are being kept out. They know the pool isn't open, and certainly if the association has its affidavits in place, then they can enforce and call the police. Of course, you can call the police anytime if you see that happening, because they're doing something they're not supposed to do, and it is a crime. But and of course, you can consult with your attorney as well to discuss those affidavits and make sure that's something that would work best for your community.
All right, and our last question, we're going to wrap this up, guys. So sorry if I missed this. Have you covered streaming HOA meetings on Facebook? No, we have not. So can you? Yes. Should you? Probably not. And the reason being is, meetings of the association are for the members of the association. And so on Facebook, anybody with a link basically can get in, versus if you had a more secure method or platform of holding the meeting, you're going to reduce, you're probably not going to completely eliminate, but you're just going to substantially reduce people that really have no business watching or listening to the meeting from that occurring. So again, there's nothing improper about it. Let me be very clear on that. If your current board likes to use Facebook and it works well for you guys, and you're okay with it, I mean, you can do it. But again, keep in mind that individuals that may no longer live in the association, but they had an axe to grind with the association before they left. I'm sure they still have neighbors that they're buddies with, and if the neighbor sends them the link, then they can access the meeting and hear what's being said, and try to catch the board in a slip up. So that's why it's better to have a more secure platform for your meetings, just so that you can regulate as much as possible and limit the attendance of those meetings to those people that should be there, and people that should not be there. So that is it. Would it satisfy the requirement for holding open meetings? Yeah, it would. I
Yes.
mean, so long as you give the proper notice and the login information, yes, it would. All right. Can we
No.
put Zoom link on our lockdown portal? You're welcome, Andrea. Can we post the Zoom link on our lockdown portal? Well, the Zoom link has to be on the notice of the meeting to the owners. So if we're talking about, let's just say it's a board meeting, for example, the Zoom login credentials have to be on that meeting notice. So however that's distributed to the owners, so long as it complies with the property code, then you're fine. If it doesn't comply with the property code, then you're not fine. So if you have any questions about that, I would suggest you go with your legal counsel and make sure that however you guys are disseminating that Zoom login information is done in accordance with 209. Again, assuming you're a 209 association, is done in accordance with that. And so there we are done. We'd like to thank everybody for joining us this afternoon, and hope this was informative and helpful. Again, thank you for taking the time out of your day to join us. Teddy, any final closing remarks?
No, just thank you for being here, and hope to stay in touch, obviously.
All right, everybody. Again, thank you so much for joining us. Hope you guys have a wonderful rest of your week, and we'll see you on the next one. Take care. Bye-bye.
Bye, y'all.